welcome to the channel. Today we're going to check out Judge Simpson down in Washtenaw County, Michigan. Ann Arbor is the city. We're going to check him out, analyze him. I love this judge. He's quirky, he's sarcastic, and he can get upset, is the term I'll use. Animated. So let's dive into it and see where we go.
In a district court for County of Washtenaw, State of Michigan, session. All those having business before the court are near. The Honorable Judge Dave Sessions, clerk of the docket.
You may be seated. Oh. Whenever I look over there, I never know who's. Ms. Feltes.
Good morning, Your Honor. Actually, Lonnie Feltes for the people. Your Honor, at this time, people would waive any conflict between this honorable court and the honorable defender. We do not believe that any conflict exists. Make clear to the avoidance of all doubt.
Thank you.
Assistant Public Defender Hannah Apple, on behalf of Public Defender's Office, our office does not believe that a conflict exists between this honorable court and the Public Defender's Office. One did arise, our office would waive that conflict. This court could hear this matter.
All right. The court, for its part, also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Carlos Edwards. That's
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Yes, Stephanie Cannon, on behalf of Mr. Edwards.
all right. Mr. Edwards,
Yes,
can you state your name, please?
Carlos Edwards.
Thank you, sir.
I am scheduled to meet with him on Friday at 10 a.m. So I just need a 1 week adjournment to meet with him Friday.
He's in MDOC.
Yeah, he's in, what is it, the SF one?
2 weeks.
Excuse me.
Yes,
I would
Mr.
like
Edwards.
to say that I have class in order to proceed with my out date. Can it be Thursday that you can come see me in the court date on the following Thursday or something like that? Because them the days that I have off a class.
When are we adjourning it to, Your Honor?
There's off days.
Yes.
What?
When are you adjourning?
It would be the 13th. I would give you the 20th if that will help you with scheduling.
Okay, and Mr. Edwards, what you want? Days.
At times she is.
Yeah. I mean, I'm trying to get this matter taken care of as soon as possible because it's holding me up.
I'm gonna speak with you at 10 a.m. tomorrow, Mr. Edwards. Thank you, Your Honor.
November 20th, 2025, 9 a.m. Bond continued. Thank you, sir.
20. Yes.
Yes, on the
October
20th. All right, thank you. The court does call the case people versus Jacob Halfacre.
20th.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Your Honor, Michael Vincent on Mr. Halfacre.
Good morning, sir. Mr. Halfacre, can you state your name, please?
Jacob Halfacre.
Thank you. You'd like this adjourned?
Yes, I talked to him yesterday.
Man, that prosecutor, Kenneth Overwater, man, he just sounds thrilled to be here, doesn't he? He is just absolutely monotone, boring, and he just acts miserable. Look at his face. Watch his expressions. He has none.
And he clearly is, he's at the forensic center right now. I'm not sure how long or.
Why don't we do this? December 4th or the 11th? I'm so glad you turned around because.
December 4th, Your Honor. Thank you.
All right, thank you. We'll adjourn the matter. Is this a? Yes. I'll adjourn this matter then to December 4th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you, Mr. Halfacre.
Thank you.
Where's Miss Cannon? So no, I don't need to talk to her. Just tell her I did not get a green sheet from her. That tell her I'm angry. All right. No, just make up whatever you need to. Court calls case, People versus Devin Lyons Nash.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Lyons Nash, who I'm having trouble seeing.
Oh, there. Okay, gotcha. Mr. Lyons Nash, can you state your name, please?
Devin Jeremy Lyons Nash.
Thank you, sir.
Your Honor,
Yes, sir.
this is an adjourned probable cause conference. I have filled out the paperwork to visit Mr. Lyons Nash with MDOC. They have received it. They're doing a thorough background check, and I have not passed it yet. But I'm hoping to in the near
Wow.
future.
You think you will?
What?
Devin Lyons up there in the top of the screen. He's at Lakeland Correctional Facility in the Michigan Department of Corrections prison system. That's what the LCF is for. Now, that's just simply a transport code for the facilities that they use. It's generally that's what it's for, is like administrative use. It's not like people from the public don't really use that unless you've been to prison or, are an employee corrections officer or whatever, but that's what the LCF means, is the coding for that. So Lakeland Correctional Facilities in Coldwater, which from what I've been told, I've never been there, but I've been told that it's huge, and it's a pretty good facility. Like there's quite a bit to do. It's huge. It's massive. They've got everything there, and it's pretty laid back from what I've been told. So he's got it made. Don't let him make you think that prison isn't cushy, because it is. At least in Michigan, it's cushy.
It's my most sincere wish, Judge.
I'm just hoping they don't call me.
So I'd ask for an adjournment, and if possible, maybe to expedite this matter, I do have a paralegal here that can hopefully, if after we're done, if he could have a breakout room, we can help.
Are
Mr.
you
Nash.
serious?
Well, no, I don't need a breakout room. I was hoping that he and the paralegal could have one after we're done, and it wouldn't inconvenience anyone.
This is that whole Gretzky thing, isn't it? Is that what this is? You know there are certain things I don't do.
Yes, I was hoping that, under these
It's like
extraordinary
show
circumstances.
causes and that. Why do you continue to do this?
Just one of God's little jests. I don't know.
You are not passing the background check. I know it's not. And it's because of behavior like this. Because the moment I say yes, and I get that the moment I say yes, every one of them is going to want to break up. See?
Well, Miss Cannon just collects them like baseball cards.
November 20th, 2025, 9 a.m. Uncontinued, and no, there will be no breakout room.
Thank you.
Nice try.
All right, I'll come visit you as soon as I'm cleared, Mr. Nash. Thank you.
Yes, sir.
2027. Court calls the case, People versus Caitlin Stevens.
So that lawyer basically he tried to sneak a visit in with his client, right? And I get it. I get what he's trying to do. So I'm sure it's like this in most other states, but in Michigan prisons and the Department of Corrections, in order to visit someone, you have to go through like a pretty rigorous process, basically, in my opinion. You have to go through a background check, all this stuff. They have to send in an application. They have to mail it in, and then they have to wait for a response. It's quite a long process. Like I think a couple weeks at minimum. And so he's trying to skip over that and avoid that process. So that's why he said, once I get approved, I'll see you as soon as I can. So he tried to play a fast one, and the judge caught it. Judge Simpson is not dumb. Let me tell you what, I'm the first to tell you here, he ain't dumb. This man is very smart, but he will play dumb. He will play dumb.
Assistant Public Defender Nicholas Bukovich on behalf of Ms. Stevens, who is appearing via Zoom. Ms. Stevens, can you please state your name for the record?
Caitlin Stevens.
Okay. I have before me, she has two cases. I have before me plea forms that indicate she's going to plead to 2 charges of false report of a misdemeanor, which is count 2 in each case. Upon the 93-day offense, upon her successful plea to those charges, count 1 would be dismissed. That is the court's entire understanding of the agreement.
That's correct, Your Honor.
Ma'am, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right. State your name again for the record, please.
Caitlin Stevens.
All right. Ms. Stevens, it's the court's understanding that you're going to plead guilty to 2 charges of false report of a misdemeanor. Those are, as indicated, misdemeanors themselves, punishable by up to 93 days in jail, $500 fine plus court cost. Do you understand that?
Yes, sir.
All right. You also understand, ma'am, that on one of the cases, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir, I do.
All right. To the charge of false report of a misdemeanor contained in case file ending in 1156. How do you plead?
Guilty.
To that same charge ending, appearing, or contained in case number ending in 1001. How do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or had one signed on your behalf.
Yes, sir.
You have any questions regarding any of those rights?
No, sir.
You understand that you're waiving all the rights contained in that form, including those under paragraph 5, which are your trial rights.
Check out Homegirl over here in the bottom right of your screen in the orange jumpsuit in the window there. Looks to me like she's in segregation, administrative seg, which is the whole, or some kind of maximum, but she's in jail, it looks like, not prison. It looks like the corrections officer's out there holding the tablet for her. She's probably going to talk through those little holes right there, I would imagine. Check it out. Watch her. Interesting.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
At the
You're not.
moment, no.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
If you can't tell, she's in prison attire. She's in prison. She's at Women's Huron Valley Prison in Ypsilanti, Michigan, is where it's at. So that's why they were laughing and joking, because obviously she's not on probation or parole. She's in prison.
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
All right, starting in the case ending in 1156, on the date of August 6, 2024, at the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, State of Michigan, what do you do on that date that makes you think that you're guilty?
I falsified a police report.
Say that again.
I falsified a police report of being assaulted in the prison.
Okay. And the information that you provided to authorities was false and you knew it to be false?
Yes, sir.
All right. Going to the other matter on the date of June 22nd, 2024, at the location of 1880 Ridge Road in Superior Township, Washington.
Check out
State of
Homegirl.
Michigan. What'd you do on that date that makes you think that you're guilty?
Her
False
face says,
police
help
report
me.
To the police directly of being assaulted at that address.
All right. And you knew that the information you provided to the police was false?
Yes, sir.
All right. Ma'am, if I accept your pleas in this case, as I have to advise you that if you commit misconduct as defined in the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, that you would not be entitled to, nor would the court be bound by any sentence recommendation or evaluation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea to count 2 in both cases. Count 1 in both cases is dismissed. In the case ending in 1156, how long has she been in?
From my understanding, speaking my client, she's been in since July of 2024. She was not arraigned until September 2025.
All right. And this is not a victim's rights. Ma'am, since this case is mine, is there anything you'd like to say before I impose sentence?
No, sir.
And counsel, any objection to be proceeding to immediate sentence?
No, not at all, Your Honor.
In that case, fines and costs, statutory fees of $125, sentence you to 93 days incarceration, credit 93 served.
On each case, Your Honor.
Well,
One is a 14A2 case, so that would have to be sentenced in front of Judge Barr.
I'll take the hit. If he gets upset, I have a feeling he won't. I'll also, on the other case, since it's a 14A case, I'll sentence him. You have any objection to me sentencing you on that case, ma'am?
No, sir, I do not.
All right. Fines and costs of $125, 93 days, credit 93 served.
Thank you, Your Honor.
So, Ms. Stevens, both your cases are closed out now.
Thank you so much. So I can get the parole board to let me go.
All right. Thank you, ma'am.
Thank you so much. Have a good day.
You too. Can you just inform Judge Barr's office I did?
She's happy and giddy. One, because what just happened there is basically he gave her the max of 93 days for that charge and sentenced her to 93 days, but gave her credit for 93 days because she's been in prison since July of 2024, I believe they said, or June. I think it was July. But so that she's been in there since then. So all that prison time she's done counts towards any charge that was caught to her going to prison. Misdemeanor wise, generally they'll run all of that together. So now that she's gotten that taken care of, she had open cases because she was waiting to be sentenced and get those taken care of, those cases taken care of. She couldn't get out of prison and be released by the parole board because the parole board, all they know is that she has open cases, pending cases. So to them, that's a bad check mark because you have open cases, pending cases, even though you caught them prior to or whatever the case may be. Well, she caught them in prison actually because she lied on a police report about something, I forget what. But so basically now she should be able to get released because she doesn't have any open or pending cases because the parole board's not going to let you out of prison if you have pending litigation. So now she's happy. She's super excited, as you can tell. Let's carry on.
Thank you so much, Your Honor.
And then tell him he's welcome. Court does call the cases of the people versus Renee Williams.
I've got the best news in They dropped.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Williams. Ms. Williams, state your name for the record if you can hear us.
Best news of her life.
Thank you.
Your Honor, I am referring Ms. Williams for a competency evaluation.
All right. You have the paperwork, or you're gonna,
I have the orders. I just need to fill in one more part.
all right. So a forensic evaluation will be ordered. I'll set a competency hearing for January 29th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Thank you.
Thank you, ma'am. Court does call the case of the people versus Taylor Byer. And
People.
Good morning, Your Honor. Please, this honorable
you know
court.
which one.
Brandon Bird on behalf of Taylor Byer. Mr. Byer, can you please state your full name for the record?
Taylor Martin Byers.
Good morning.
Good morning.
Good morning, sir. All right. What are we doing?
Respectfully requesting the adjournment, Your
Out of
That's the
objection,
hood
the
lawyer.
Will be adjourned to November 13th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank
Do
you.
your honorable court have a great day, Your Honor.
You do the same. Court calls the case of the people versus Casey Atkins. Is that really it? Is that really it for you?
That really is.
That's so strange.
Good morning, Michael Vincent on behalf of Casey Atkins.
Your name, ma'am?
Casey Atkins.
All right. You're requesting an adjournment of this.
Yes, we are in negotiations
Okay.
as we speak.
Will the 20th work?
Yes, Your Honor.
All right, thank you. Probable cause conference, November 20th, 2025.
Good.
9 a.m. She's so nice.
Yes.
So yeah, the people in your office are really nice. They
You know.
didn't get that from you. But okay, I just wanted to make that clear. Bond continue.
Thank you, Your Honor.
Court calls the case of the people versus Noah Boren.
And then on behalf of the people.
Good morning, Your Honor. Wade Fink on behalf of Mr. Bowron, who I believe I see is present there in court.
Yes. Your name, sir?
Noah Bowron.
All right. What are we doing?
Your Honor, I have had an opportunity to speak via email with the prosecutor. I've received a substantial amount of discovery, which I appreciate. There are some things I'm curious if they do exist and if I have everything, not by anyone's fault, but just to make sure that everything was turned over. So I would ask for one more PCC judge, and then I think we'll be ready to set an exam date if the court.
Not a problem. You want the 13th or the 20th?
I think the 13th is plenty of time. I'm going to get on this and send a list over.
All right. Probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond will continue. Thank you, sir.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Kaida Matson.
Good morning, Your Honor. Kaida Matson.
Michael Vincent on behalf of Kaida Matson.
I have called some people.
That was
Either.
absolutely backwards. But go ahead.
Prelim.
I'm sorry, Your Honor.
No, it wasn't your fault. It was Vincent. What are we doing in this case?
You know, it's like home. I get blamed for everything. Feel right at home here. We need a prelim date, Your Honor. We have everything.
All discovery is complete.
Got everything.
Yes, Your Honor.
All right. And oh, okay.
Call me when you are.
Okay. Okay, so it's a bit of a strange, where I would set these, they're a bit strange. I can set it on Monday, the 10th, or else it would be set on November 13th.
The 13th would work better. He has another.
All right. Preliminary examination in person will be November 13th. Yes, 2025 at 10 a.m. And that's before Judge Barr.
Judge, we couldn't hear the last.
Barr.
Judge Barr.
Yeah.
Yeah.
Okay. I will.
People would have their witnesses available that date. I should have asked. All right. Bond will continue. Thank you. Court does call the case People versus Winona Harvey.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Harvey, Your Honor.
Ms. Harvey, can you state your name, please?
Can you say your name? No. I can't say my name. My name is Nona Harvey.
Oh, wait, what's your name?
I say my name is Nona Harvey.
Okay.
Your Honor, yep, I did have a chance to meet with Ms. Harvey. I did explain to her, I did not receive any updated competency report. I don't believe Mr. Overwater.
This is why I love his patience. I just absolutely adore this man because he doesn't really have this patience that he's expressing and showing. He does not. But he's definitely able to hold it together and be professional. And I appreciate people like him because this would be a hard job, in my opinion, on certain days.
Water has either when he and I spoke.
I have one. Well,
the last one was September 23rd, I believe.
Well, actually, recordings are.
Now we see why they had her in a cage behind a locked door. She seems a little unstable.
I did receive one. September 12th.
I think she's been in court since then.
Well, this was from September 23rd, so we're basically at the review and we haven't received anything. Well, the last hearing we had, I have no report.
Oh.
And I adjourned it to today. And so that was on September 18th. On the 23rd of September, we received a report.
Oh, may I approach and have a look at that?
Yeah. I don't think the way that. Yes, counsel can approach. This one's on.
Sir, can I approach on behalf of Mr. Overwater?
Yes, you can.
Thank you.
This guy in the Nike hoodie, black Nike hoodie, is applying for a visa. It looks like he's been writing for decades.
Send it to Mr. Overwater and Mr. Katie. All right, apparently we have received a report in this matter. We're going to send it to counsel. And then what I would do is I'll adjourn this out 1 week. So probable cause conference in this matter will be set for, is that the 6th? Or competency will be set for November 6th, 2025, 9 a.m. for counsel to go through that report. I'll continue.
I'll come visit you with the report, Ms. Harvey. I'll make sure I keep this case, Judge.
Okay. Thank you. The court does call the case People versus Savannah Bradley.
National Office for the People.
Good morning, Your Honor. Kevin Madish on behalf of Mr. Bradley.
Good morning. And your name?
Savannah Bradley.
All right, I have before me a plea form that indicates the defendant will be pleading guilty to count 3, retail fraud in the 3rd degree, the 93-day offense, and count 4, use of methamphetamine, a 1-year offense. Upon our successful plea to those charges, counts 1 and 2 would be dismissed. There is a sentence agreement of no 7411.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
He said no 7411. So 7411 is basically a program that I believe it's for drug charges, like possession charges and stuff, misdemeanor drug charges. I'm pretty certain that's what it's regarding, but regardless, it's a program for people that catch misdemeanors, I believe first time offense. And if they complete probation in the programming, they will have the charge removed from their record, expunged, if you will. So that's my understanding of it.
Savannah Bradley.
All right. And I should say on the sentencing form, there's a sentencing judge waiver, but that doesn't need to be filled out because it's not the case.
Yes, Your Honor.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to 2 misdemeanor charges. Is that correct?
Yes.
All right. The first is count 3 of retail fraud in the 3rd degree. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
Count 4, also that you'll be pleading guilty to, is use of methamphetamine. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. You understand that?
Yes.
All right. Understanding all of that, do you still wish to plead guilty?
Yes.
To the charge of retail fraud 3rd degree, how do you plead?
Guilty.
To the charge of use of methamphetamine, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal up?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you're guilty of these offenses?
Yes.
July 20th, 2025, at the location of 3749 Carpenter Road, Pittsfield Township, Washington County, State of Michigan. What did you do at the Target store that makes you think that you're guilty?
I put items in a bag, that I scanned the bag, not the items.
Okay, so it was a bag from the store?
Yes.
Okay, you put items inside to conceal them?
Yes.
Scanned the bag, but didn't scan the items inside?
Correct.
You did that intentionally?
I did.
And you tried to walk out without paying for them?
Yes.
Store was open to the public at the time?
Yes.
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you put inside and didn't scan, these were items that were offered for sale by Target?
Yes.
All right. On that same day, did you have methamphetamine in your possession?
I did.
Had you used it?
I did.
Did you know what you were using was methamphetamine?
Yes.
All right. Ma'am, if I do accept your plea to these charges, I have to advise you that if between this time or the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to any sentence evaluation or recommendation, nor would the court be bound by that. And you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is still satisfied, Your Honor.
All right, court will accept the defendant's plea of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. 14A1 probation. Sentencing in this matter will be. No, she's in custody. Thank you. Sentencing, November 12th, 2025. 10 a.m. Before me.
Your Honor, may I address bond forward?
Be disappointed if you didn't. Go ahead.
Your Honor, first of all, we had been wanting to ask for a reduction in her bond that is currently set up. Miss Bradley has not seen her son for about 80 days. She was in custody of Wayne County for around 75 days. Her son is currently with her dad. She needs to get him enrolled in school before CPS starts getting involved. She is okay getting released on GPS tether, on any alcohol tether, and do any sort of testing that Your Honor decides to order. She's even willing to be put on.
She didn't do that the first time, though.
That was,
I mean, the reason that she's in, she had a PR. She didn't comply with community correction and didn't appear.
yes, understood, Your Honor. And she does have a letter that she wanted to share with you. I've already shared it with the prosecution. We could provide it to Your Honor if you would allow us to. She does apologize for that.
So you want me to stop in the middle of everything and read a letter?
No.
Oh, okay, go ahead.
I mean, I guess I can summarize it to you. It's a really heartfelt letter. She's saying in it that she apologizes. She wants to be able to get back to her son. She's been far away from him enough. She is interested in rehab. I would have asked for her to be released into rehab, except the fact that she does want to be able to go and get her son situated in school. That's the only reason we haven't already submitted that. She just wants to make sure her son is kind of, he's already late, to get enrolled. But that's what she included in the letter. And she can speak to it herself.
He is not thrilled at all. I think he hears excuses and justification and, I mean, blatantly avoiding the fact that she just skipped court or whatever she did. And now it's all about her son and all about getting her son in school. Now you have priorities. Convenient.
Sorry, yeah, I just did the 75 in Wayne County and I got and came here right the same day. I had to move from my current house to my dad's house. My boyfriend left me when I was in Wayne County. So I got to get him in school because it's about a 30-minute drive from my dad's house to a school that he's having a hard time with. And I just need to get him enrolled over there so he can get in there. His son or his dad currently don't have power at the house. So that's why he's staying with my dad. And he's just having a hard time getting back and forth to school. I'll do
Wow.
anything.
Pardon?
I'll do anything the court asks.
Well, ma'am,
I know I messed
gave
up.
you the
I know.
yeah,
I know I
really,
did.
you messed up
I did.
big time. And now you want me just to give you another chance to apparently mess up, and you've not received any treatment. You've not received anything, which was part of the reason why you ended up with the bond that you did, and you ended up incarcerated because you were using.
I know.
So, and I'll be honest with you, and I mean, I don't mean to be harsh about this, but I think it's true. I don't know how good you do your son if you're using, and you've done nothing to sort of alleviate that part of the issue.
I don't want to use anymore. I haven't. It's been 80 days.
No addict
I
that
can
comes
do it.
before me wants to use.
I'm not going to.
Ma'am, how many times have you made that promise to yourself and to others?
Once. I started using in June. It's the first time. I've never done drugs. I never have drug
So
cases
you only
anywhere.
one time previous to what you just stated to me promised that you wouldn't use drugs.
I mean, when I messed up the last time.
You made that promise.
I haven't used drugs in 75, like 85 days. And I know I
Because
could do it.
part
I
of that,
don't want
we've
to.
had you.
And I'm glad that Wayne County took me because if they didn't, I probably would still be using.
It's been 80 days since she used. 80 whatever, 81 days she said. But she said she just started using drugs in June. It's the end of all of October, all of September, and all of August that you've been locked up. So you used for a month and a half, maybe, and it caused all this. Honey, you got some issues. If that little short period of drug use caused that much damage to your life. Been there, done it. And let me tell you, it took a little bit longer than that. So I think there's a little bit of fibbing going on here.
But I haven't, and I feel good that I haven't.
Anything else? I don't need a response from the people. Motion for bond reduction is denied. I may reconsider it after she's evaluated by probation, but at this time I'm going to deny the request. Bond will continue.
Understood, Your Honor. Thank you.
Thank you. Court calls case, People versus Lydia Bevere Whitfield.
Good morning, Judge Christopher Quinn, appearing on behalf of Ms. Whitfield.
Your name?
Lydia Bevere.
We're just asking for one more PCC, Judge, for discovery purposes.
Probable cause conference in this case will be adjourned November 20th, 2025, 9 a.m.
Could I get the 13th, Judge?
Why?
I'm anticipating potentially having a trial.
And give you the 13th, but when you can't get out of here that day, don't yell at me.
Thank you.
November 13th. 9 a.m. Court calls case, People versus Douglas Brown.
John Overwater, Assistant Prosecuting Attorney for the People.
Court, Your Honor, Michael Vincent on behalf of Doug Brown.
Your name, sir?
Douglas Brown.
Thank you.
We need a prelim date, Your Honor.
Discovery is all complete. All right. And people would have their witnesses available. I think the last time, the 13th was a more convenient day for you. So people would have their witnesses available on the 13th.
I believe so, Your Honor.
Yeah, that phone though.
Preliminary examination in person, November 13th, 2025, 2 p.m. That is before me. Bond continue. Thank you.
Thank you.
Court calls case People versus Denicia Charles.
Assistant Prosecuting Attorney on behalf of the people. Good morning, Your Honor. Edward Drugas on behalf of Denicia Charles, who was approaching.
Her name, ma'am?
Denicia Charles.
Thank you. What are we doing? Your question?
I'm asking for an adjournment today. There's some outstanding media.
That's correct, Your Honor. I agree with the adjournment. In addition, I want to amend the bond to allow victim Brian to have contact with her mom. Her mom.
If you submit an order that's stipulated to, I'm not going to have an issue.
And I also would agree to, there's potential that we're going to dismiss count one, which is the child abuse. So I have no objection to the tether being removed. They're currently working with CPS, the mom and the victim. So we are both requesting that removal. They have allowed contact, no GPS tether, and I can put that in.
Put it all in an order.
Thanks.
How much time did you need, Mr. Drugas?
2 weeks.
Probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond continue. Thank you, ma'am. Court calls case People versus Cortez Bryant.
Good morning, Your Honor. Sam Bernstein for Mr. Bryant. I've lost my voice. It's gonna be a long day. I have like 10 PCCs.
Yeah, but it's kind of pleasant you left your voice. Sir, your name? Cortez Bryant. All right, what are we doing? You're afraid to say anything now. Go ahead.
Can we please step for exam, Your Honor?
Yes.
Discovery is complete.
Thank you.
I lost my voice. Obviously. Thank you.
Would the people have their witnesses available? Well, I can set it for the 10th or the 13th.
Could I please have the 13th, Your Honor?
13th?
Yes.
People have their witnesses available the 13th. Preliminary examination in person will be set November 13th, 2025, 9 a.m. That is before Judge Barr. Or I'm sorry, 10 a.m. before Judge Barr. Bond will continue. Thank you. Court does call the case People versus Rayshawn Dawson.
So I think the guy in the Nike sweatshirt is actually, the black Nike sweatshirt is actually doing homework. College homework is my guess. But with that said, what do you think he's going to school for? What kind of homework do you think he's doing? Let me know in the comments what you think.
I'm gonna go grab.
Carmen, I got it.
Oh, okay.
Sam Bernstein, I can stand in for Ms. Foster Tucker for Mr. Dawson.
On behalf of Mr. Dawson on the case ending in 1437.
All right, your name, sir? Rayshawn Dawson. All right.
We are asking for an exam, Your Honor.
Well, are you both asking for an exam?
No.
You're asking
I'm
for.
asking for an adjournment, yes.
Okay, let me do the adjournment first. So probable cause conference in this matter, that being the 1437, will be adjourned to November 20th, 2025, 9 a.m. Bond will continue on that case. Okay. Then on the other matter. Charges on the side. And you don't have Mr. Foster Tucker's schedule.
The 13th looks better, Your Honor.
You don't know that.
I do.
You're just saying that.
No, Your Honor,
You're just saying that. You have no idea.
I reviewed the calendar.
Because I was going to set it for the 10th. You reviewed it?
She can make the 10th work as well.
She can? Then
Yes,
why do you say that? Never mind. Don't talk because I don't want your voice hurt. I know. What's funny about this is
I just absolutely love his humor. It's just great. I mean, could you imagine working with this guy? I mean, it would be absolutely great to work with this guy every day. Unless he's in not a good mood. Then it wouldn't be very good to work with him then. It'd be like, I don't know, man. I'm not going to work today. Judge is not happy the past couple days. I'm gonna call in today.
you're not having your, I can come at you all day.
Wait till my bond arguments.
So what I'm gonna do, because would the people have their witnesses available to 10?
We'll try, Your Honor.
All right. What I'm gonna do, sir, is I'll set your preliminary examination in person, November 10th, 2025, 9 a.m. That's before Judge Balro.
That's here.
That's here. Okay. That's on a Monday because of the holiday in the week. All right. Bond will continue. Thank you. Court does call the cases of People versus Man Davis.
Actually, Phelps for the people.
Edward Lucas for Man Davis in 1167 and 1367.
And good morning, Your Honor. Assistant Public Defender Chinazi Carey Akinruli on behalf of Mr. Man Davis. Mr. Davis, take your name for the record.
Man Davis. We all knew.
Judge, you respectfully request that I believe all the matters be set for preliminary examination.
Okay. So all discovery is complete on all of these matters?
To our knowledge, Your Honor, yes.
All right. And would the people have their witnesses available on the 13th?
We can try for that day, Your Honor.
Preliminary examination in all of these matters will be set for November 13th, 2025, 10 a.m. That's before Judge Barr on all matters. All right.
Thank you, Your Honor.
Bond will continue. Is that it?
Santana girl, you left a big old gap in the middle. There's no hair. You forgot some. What are you doing?
For Mr. Davis, so I won't see him again?
That is correct.
All right. Take care. All right. They're in Zoom. Court calls the case People versus Brandon Myers.
Take this call for you.
Morning, Your Honor. Michael
Yes.
Friday, Assistant Public Defender on behalf of Mr.
Simpson.
Myers.
All right. Your name, sir?
State your name.
Okay. He doesn't want to state his. Are you Mr. Meyer?
He's stating his name.
Okay. Thank you. All right. What are we doing?
Your Honor, I have to ask for an adjournment. I went to see Mr. Myers. He was not available to be visited when I went to see him. I'll try again. Ms. Anderson from my office asked me to let you know there's a new case that's on the arraignment list today. I don't know if the court wanted to.
Today?
Yeah. He's on the 130 docket. It looks like it's a failure to return rental property, 1,000 to 20.
Okay. So what I'll do is I'll adjourn this to the 13th, 2025, 9 a.m. Bond will continue. Can you let the
You go to court on the
magistrate
13th, I got
know
adjourned.
to put this on the 13th? I think that's the
Oh,
date
no.
they'd land anyway. Thank you, sir.
I'll come visit you, Mr. Myers.
Well, I'll tell you what he said.
Pardon? Okay, he's got it. Court does call the case. People versus Kyle Wilson.
I'm on behalf of Mr. Wilson, who is approaching.
Carter Wilson. You're requesting an adjournment. Can counsel approach, please?
Esteban, Your Honor, Your Honor.
All right. All right. You're requesting an adjournment.
Yes, and a moment to address bond, Your Honor.
All right. Probable cause conference will be adjourned to November 13th, 2025, 9 a.m. As to bond.
Esteban, Your Honor, we were gonna be asking for an adjournment a reduction in the bond. If not a personal recognizance bond, perhaps a 10% privilege. Mr. Wilson, to my knowledge, has not had any bond violations while he has been in custody. He has a really good full-time job that he's afraid to lose. He does have 4 children to provide for. One of his children typically stays with him, is now staying with his sister. One of his other children, he usually stays with throughout the day. So he'd like to be able to get released so he can go back and take care of his children and be able to provide for them. He also has let me know that he has somewhere else to go. He has he can either go to his sister's house or to one of his children's mother's addresses. Neither of those are in Washtenaw. He's okay getting released on a GPS tether. He has no reason to come back to Washtenaw except for this case. The house that he could go to, his job is in Southfield. And then I believe your sister's address is Oak Park, and then the child's mother is in Westland. So really far away from here. Well, not really far away, but far enough. We can do a hot zone tether with a GPS zone that's quite big. He will not violate. He just wants to be able to get back to his job so he doesn't lose it and be able to provide for his children.
Respond.
You're not going to strongly reject any modification of bond. In this case, he originally requested $150,000. He is currently on probation out of the 6th Circuit Court for a GBH and DB. conviction that he pled no contest to. As far as I saw on their website for that case, a bench warrant had been issued at this time. In this case,
Hold on, I just want to make sure I understand it. At the time, the alleged time of this offense, he's on probation.
for a DV, GBH, and DV charge that he pled to.
All right, and there's a bench warrant that's being issued. Was that bench warrant issued in response, if you know, to these charges, or was there something else where he was non-compliant?
I believe it's these, I don't know exactly, it just says order for bench warrant issued on 10/22 of this year. If I may, Your Honor.
On 10/22, so that was probably, go ahead, Counsel.
Yes, I believe that's his violation. In Wayne, he is in contact with his probation officer, has a good relationship with her. He knows about that. He's complying with that. He was about to be discharged November. He has done everything he's supposed to do. He was ordered to do, anger management classes, and he completed what he was supposed to complete, and is still doing more classes on his own, whim. He felt like it was helping him, and again, he was doing very well. He was about to be discharged. He was waiting on the discharge letters.
He was doing everything he was supposed to do except have contact with the police and potentially commit other offenses.
Yes,
right?
Honor.
That's what you meant to say.
That's what I meant.
Go ahead.
He was about to finish another strangulation and domestic violence case, and in this case, the victim is extremely terrified of him.
That was a straight mic drop. That was pretty epic. I like that because that's what he does, man. Don't lie. Don't beat around the bush. Just say it for what it is. She said 40 seconds worth of word salads just for him to say that when literally she shouldn't have said any of that because he's still violated. So it doesn't matter whether he has been squeaky clean for 8 years. He's still violated. So it's not just going to get swept under the rug. Sorry.
She reported 2 different strangulation incidents, one that was out of county and one in Washington, and that the defendant had left her car for an extended period of time and she wanted it back from errands. He became extremely upset, told her, "Stop telling me what to do or I'll beat your ass." He then balled up his fist, began pushing at her as if he was going to hit her, then pushed her to the ground, which caused her to fall on top of her son. He then had one hand around her throat, one over her mouth. While she's still on top of the child, strangled her, and when law enforcement arrives, he refuses to come out of the house. Officers had to kick in the door, which it was stopped partially by the deadbolt. They eventually were able to kick it open fully and arrest him, at which point he was still tensing up, pulling away. And during these assaults, he had also told the victim, "I wouldn't kill you because nobody's worth me going to jail for life. I'd have someone else do it." So I have extreme concerns given that a new strangulation case occurs while he's about to probation for a strangulation case that he pled to. And he's also resisting law enforcement officers at the scene of this event. So I have concerns for the victims, the community, law enforcement, and the high lethality factors in this case. So I would reject any modification of bond at this time.
I just add, Your Honor, that these are just allegations at this point.
Yeah, but
Let me make it clear before I say anything. I do not condone any of his behavior, anything that they're talking about. But with that said, people say things out of anger when they're angry and they're raging mad and all they see is red. People say things that they don't necessarily mean, or that maybe they didn't necessarily mean it to come out that way. Yeah, he said them, whatever. That's understood. It's still terrible that he said it. He shouldn't have did it. Okay, there's consequences for that. But I'm just saying, the prosecutor, they always act like they're just monsters. Everybody's on apps. It makes me wonder how they sleep at night.
I'm presuming that some of that we can probably see because the door, there's physical damage to the door.
Yeah.
And while there are allegations, certainly there becomes a problem if all of this is going on and there's a lack of cooperation with police officers.
I don't, again, want to speak to the exact details of the case, but from my review of the video, Your Honor, again, I don't want to get into the details, but it's definitely questionable whether he was resisting arrest or not in my review of the videos.
In looking at this, frankly, his bond currently is set at $75,000 cash surety. I'm going to deny the request for a reduction. I do find the defendant, having been on probation and then allegedly committing these offenses, to be a danger and risk to the public. Quite frankly, and I did not take their indication of what they had requested as a request to raise the bond in this case. I will decline to do so, although I think that the bond in this court's mind, based upon what I'm seeing, may be set too low. So I'm going to leave the bond where it is. I'll have his bond continue, but I'm certainly not reducing it.
Thank you, Your Honor. Understood.
Thank you. Court does call the case People versus Colette Haynes.
Overwater Assistant Prosecuting Attorney for the people.
Posture check around behalf of Colette Haynes.
Hello.
Hello.
Your name?
Hello. Hey.
Why was Mr. Bernstein stepping in for you?
Sorry, Your Honor, I had another court.
Oh, we would have rather heard from you. Just saying. But go ahead. Anyway, what are we doing?
Your Honor, we're just requesting an adjournment to try and work out a resolution.
Press conference November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the people versus Marissa Dix.
Good morning, Your Honor. Great to see you. Robert Ellman with and on behalf of Marissa Dix. Ms. Dix, you please state your name for the record.
Marissa Dix, good morning, Your Honor.
Good morning. Thank you, Your Honor. We'd be asking for an adjournment in this matter. We just need a little time to try to reach out a resolution here.
Probable cause conference will be adjourned to November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you. Bond continued. Thank you.
Thank you, Your Honor. That sounds good. Thank you so much.
Court calls case people versus John Hacker.
Haker.
John Hacker.
Yes.
All right. Mr. Jerkis is here. All right. What are we doing on this case?
On behalf of the defendant, I'm asking for a preliminary examination, Your Honor.
All right. Discovery is complete.
Yes.
People have their witnesses available the 10th,
Could we potentially go to the next week, please, Your Honor?
the next week. Or all that, the 7th, the 18th. Is that right?
Yes.
You want to go that far out, the 18th? Any objection, Mr. Jerkis?
I'd certainly like to have it as soon as possible, but if the prosecutor's asking
Well,
for
if
it,
you want it as soon as possible, that's when it gets set. So do you want the 10th or the 13th? I'll set it for next week, which is better for you.
I'd ask for next week.
Okay, I know. However, do you want the 10th or the 13th? You haven't been paying attention. Listen, because of Veterans Day, the schedule is kind of messed up. So I have for the where I would set them, I have the Monday the 10th, and I also have the 13th.
I'll choose the 13th. I'll be requesting
All
the 13th.
Preliminary examination in this matter will be set for November 13th, 2025. That's at 2 p.m. That is before me.
For you?
That was a question?
Yes.
Is it?
Mhm.
Didn't I do one before?
Mhm.
Was Falthouse not paying attention? Yeah, that's before me. Yeah, I do exams.
True.
Yeah,
Seen it.
I can do those. Is that right? Yep, thank you, Aaron. 13 and 2. Bond will continue. Thank you, sir.
Thank you.
Yes, there are 3 judges on that week.
That's what I was thinking.
You and Jerkis weren't paying attention. Court does call the case. Cases of the people versus Cartier Drain.
Overwater Assistant Prosecuting Attorney for the People.
This is Public Defender Nicholas Buckovich on behalf of Mr. James.
And Sherlyn Foster Tucker on behalf of Mr. Drains on the case ending in 1685.
Your name, sir?
State your name.
Cartier Drains.
Thank you. And both of you are requesting an adjournment.
That is correct, Your Honor.
Yeah.
That's correct for me.
Okay.
Your Honor, is my understanding in my case, the APA is requesting an adjournment. I know we had a bench conference last time to discuss potential issues in Mr. Drain's case. So I would be asking for the soonest possible adjournment because this is the case that has the most great impact in holding him.
Could the issues be resolved by the 6th in terms of what needed to be looked at? That question was directed to the prosecutor.
I'm sorry, Your Honor.
Yeah.
I don't know the answer to that, but we can certainly try.
Well, here's what I'll do on both of these then, because presumably these cases are traveling together for a reason. I'll adjourn both of them to November 6th, 2025, 9 a.m. Bond will continue.
Yes, Your Honor, may I briefly address bond in the older case?
You asked for the nearest date and bond. Go for it.
Sure, Your Honor.
Doing so well.
Sure, Your Honor. Your Honor, I'll be asking for a reduction in bond in my case that the public defender currently represents him on. So today we did request an adjournment. As the prosecution does need to look into this matter a little bit more, I do understand the need for that. However, this is the case that does have the most severe impact on holding him because in this case with Ms. Foster Tucker, he has a low cash bond. He does have an address at which he can reside at if he is to be released from custody. And he has been regularly appearing at all his court dates in the past, so I do not believe my client is a flight risk. This was prior to him being incarcerated as well. So at this time, Your Honor, I'll be requesting consideration of a PR bond or reduction in bond to another low
Did
cash
we give
bond.
him a PR bond before and then he messed that up? And there was another issue. I mean, not only did he not appear, but there was also what at least may be a other violation as it regards this case, right? I mean, that's what needed to be looked into.
Yes, understood, Your Honor.
I'm going to deny the request for a bond reduction. I'm going to have his bond continue at this time. I've given him my next available date. They'll look into that and do that. Bond on both cases will continue.
Thank you, Your Honor.
Yeah.
Thank you. Court calls the case People versus Devon Gilliard. Or Gilliard? Printing's getting bad. Gilliard.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Gaillard, who appears to my right. Please state your name for the judge.
Okay.
Your Honor, today's the date.
What was your P number?
86012.
Oh, okay. Never mind.
What you thought? What do you think I said?
No, I just.
Up or down? Did I talk too fast?
I heard it.
Good.
No, I heard it.
I talk fast.
Mine's a 3. Like seems like a 2.
I've seen some
Those
ones.
things a 1. Yeah. And you're like an 8.
Yeah.
Wow. Okay, go ahead. I'm sorry.
No, I'm
digress.
seeing ones past mine now, so I feel a little bit better about it. But
Don't.
okay,
All right, go ahead.
Save it. I got it. Regardless, Your Honor.
Your name, sir, if you didn't.
Devon Gilliard.
Thank you. All right, what are we doing?
Today's the date and time set for PCC. I was retained on this matter. I have.
For those of you that don't know, they're referring to their bar number, which is apparently correlates with when they graduated law school, I'm assuming. And so by the judge saying his is a 3 number, that guy's number started with an 8. The judge's starts with a 3. They mentioned somebody else in the courtroom with a 2 and a 1. What they're saying is that your bar number shows your age because of how they give them out. So, and it's the same way in prison. Your prison number dictates kind of your age because it correlates when you first got in trouble with your first felony, at least in Michigan. And so if you have a 1 number, you're older guy because 1 numbers were from, I believe, the 80s, maybe even sooner than that, the 70s, and if you have a 7 number, that's from the early 2010s, so it correlates with things. So it's same thing for lawyers, obviously.
Received discovery. I've not gotten a chance to go through it. I'm asking for a adjournment. We are prepared to waive 21 days on the record here today, Your Honor.
That objection. November 20th, 2025, 9 a.m.
I would like to briefly address bond if
He's out. I can change that.
No.
No, okay, go ahead. No, I'm
no. He was in the military, Your Honor, so he's very prompt, upright. So don't.
What
take that.
branch?
Yeah.
Army.
I'm retired, yes, sir.
You're like 12. How are you?
Medically retired off PTSD, bipolar disorder.
Got it. All right. Go ahead.
Which actually is a great.
He said you're like 12. How are you retired? You just got dissed by the judge on the bench. I mean, come on. How much better can you get?
Great leeway into my point, Your Honor. My client, he understands the allegations and what he's being accused of. That being said, Your Honor, what we're requesting here today is my client does live in Fort Bliss, Texas. His only connection up here is with the victim in this case. But we are requesting.
He lives in where?
Fort Bliss, Texas.
On purpose.
No, he's from.
No, never mind. That was just my statement. Go ahead.
He lives there, Your Honor. Everything he has is there. He has a home there. I'm requesting that he be able to return to that home. He has retained my office. He's been in constant communication with me. He doesn't have a vast criminal history. He has no criminal history of convictions at all. He's not a flight risk nor danger to the community. And he, in theory, would be farther away from the victim, which I believe the court's ultimate goal because he is on tether, is to keep him away from the victim and keep him returning to court, which is all possible. There is one thing on his record while he was in the military. However, there was no conviction, nothing came of it. So he has no convictions either. I don't think he's a flight risk in any way, shape, or form. If he was able to get the opportunity to go on Zoom, he would go on Zoom, but he has also informed me that if he did have to come back in person, he would travel back here in person. And the only other, I know I'm throwing a lot at you, part of my motion is when the arrest did occur, the officers gave his suitcase with his only clothes in here to the victim. He did not want to go back and get that without court order or anything like that. So we're just asking for the 1 civil standby as well for him to get his belongings from there.
You arranged. The civil standby will be arranged with the police department, so I don't.
Okay, just do that on
anything
it.
to do with that.
Okay.
Your Honor, I would have no objection to the civil standby. However, I would have concerns him going all the way back to Texas, given this case. I would have concerns about him coming back in person for the exam and things. I just have concerns. He does have a past from when he was in the Army with domestic violence. They weren't convictions. They were, I think, adjudicated differently with like maybe classes or something based on what I read. They weren't ended up in convictions though. So I do have concerns, given that he would be across the country, getting him back here for this case.
Is Texas really across the country?
He's here today with me.
I mean, seriously, I mean, how, I mean, just how? I mean, as a human being, how can you just, how do you sleep at night? I mean, the man that just wants to go back to his house, you know, that he pays a mortgage for, and where all his belongings are, and probably his children, maybe, you know, I mean, how dare you say I have concerns? He's here today. He's from Texas, and he's here today in person. Didn't even ask for a Zoom hearing for this, but yet you have concerns. And then secondly, you have concerns about his past in the military, in the Army. You just said that no convictions came of it. Nothing came of it from what you read. So again, how do you have concerns? I just don't. These people are literally, I mean, they're bred to think this way. It's a culture. It's so odd.
We couldn't leave the state.
Well,
No, I.
Fair.
Who is that?
Sorry, but clearly the judge thinks she's kind of out of line too, because even he says it's really across the country. I mean, really? Lady, I mean, it's not across the country, literally. It's 20 hours away. I mean, you could get there in a day if you drive straight through. You know, I mean, the dude is obviously credible. He's obviously honorable, you know, so why not allow him that privilege? He served our country and retired early because of PTSD, probably from war. So give the guy a break. Cut him some slack, Miss Prosecutor. So give the guy a break.
So he doesn't have a residence here.
No, Your Honor, he was forced to get an Airbnb. Am I correct on saying that? He has no residence. He had no connection here except for the victim. No family, no anything.
How long were you in the military, sir?
I did 10 years. Yes, sir.
10 years?
Yes, sir.
Honorable man.
I think I'm going to let him go to Texas. I think if the military can trust him to fly around everywhere, put his life in danger for 10 years, I think I can trust him to go to Texas and come back when I tell him. So you prepare an order, counsel, I'll sign it that he may reside in Texas, but he needs to come back for any court date or when ordered by the court.
Absolutely, Your Honor, and that's understood. We appreciate that, and I appreciate you putting your faith in my client, as do I. He does have a tether on. I don't know if that's something you want to keep on or he's able to keep on.
Oh, no, he'll keep the tether.
Okay.
They're used to that in Texas.
No, they can, he's able to.
No, I don't know.
He's able to.
I just said that.
He's able to do that though, right? He can keep the tether on and still go to Texas, correct?
He can go anywhere
Awesome.
if he keeps that tether on,
Yep, yep.
and we will know exactly where he is.
Perfect. Exactly. That goes to my monitor. So thank you. Good to
Thank
see
you.
you and your staff, and I'll see you guys next time.
And you.
And you said November 20th at what time, Your Honor?
9 a.m.
9 a.m. Sounds good. Thank you, Your Honor.
Even more to the point, the prosecutor knew he had a tether on his leg, a GPS tether that tells you exactly where that man is at 24 hours a day, 7 days a week. But you, Miss Prosecutor, thought that he was a flight risk. You had some concerns. I mean, this is just absolutely absurd. I mean, this is what we're dealing with in our system. It's ridiculous. I mean, and then on top of that, to a gentleman that served 10 years in our military, obviously flew helicopters around in war, I'm assuming. And you have the audacity to do that. It's crazy.
You would think as an 8 he'd be able to retain that for that. Anyway, no, it's okay. I just thought I just make that comment. Anyway, court does call the case of the people versus Tamarian Jones.
Good morning, Your Honor. Sam Bernstein, P75402 here with on behalf of Mr. Jones.
Sir, can you state your name? No, I'm kidding. Can you state your name, please?
It's Mario Jones.
That is so.
Your Honor, I think we need to track this.
That was epic. I can't believe he just did that. But that just goes to show you the camaraderie that they have within that courtroom. This guy, this attorney's in front of this judge all the time. You know, I believe he's a public defender. And, you know, so it's just good camaraderie. You know, that's why I said earlier in the stream, what a guy to work with. He'd be great to work with. He'd be amazing. Absolutely fun, except for on his bad days.
Case, a co-defendant's case who's requesting an adjournment. And Mr. Jones would like me to address bond if it's.
Okay, so his co-defendant's case, I don't have it marked, is it?
It's Timothy Lacey, Mr. Almond's case.
He's also up this morning, Your Honor.
All right. And so you know that Mr. Elman's case, that's requesting an adjournment?
I spoke with him. That's what he wants to do, Your Honor.
Your Honor, did you ask if we'll be requesting an adjournment in my case?
Yeah, if you hadn't been talking to Bellinger, you would have heard.
My apologies, Your Honor. Yes, we will be requesting an adjournment.
Okay, thank you. Probable cause conference in this case will be adjourned November 13th, 2025, 9 a.m. All right, Esteban.
Your Honor, Mr. Jones is asking the court's consideration for like a 10% privilege and a tether bond. He would submit that it's out of flight risk. He has a home to go to in the community. He was working at FedEx before he was incarcerated, Your Honor. He can assure this court that he will attend all future court dates and stay in touch with his attorney. And he has school as well, Your Honor. Just hoping that the court would consider a 10% privilege.
Response?
Your Honor, this is an armed robbery case. Bond could probably be denied completely. And in fact, if any bond is more than reasonable.
Right, I would agree with that. Motion for bond reduction is denied, given it's a capital. All right, bond will continue on that case. Thank you. Court does call the case of the people versus Cassandra Johnson.
Asphalt for the people.
She's in there. Okay, got it.
Good morning, Judge. Christopher Quinn appearing on behalf of Ms. Johnson.
Okay. She's not here. She was in Wayne County. Our indication is Livonia PD picked her up, and so we don't know where she is now.
Understood, Judge.
I did not know, Your Honor. My last information was that she was still in Wayne.
It's Halloween. That happens in Livonia.
Except-
No, I'm kidding. I'm
Oh my
kidding. I'm
goodness.
kidding. I don't even know why I said that. All right. All right. So let's try to figure out where she is. I'll adjourn it out.
I have another PCC on the 13th, Judge.
I know, because I was setting it for the 20th and you made me set it for the 13th. I recall that, Quinn.
And I'd just like to make sure I'm on time at your court. So the 13th.
November 13th,
Thank
2025, 9 a.m.
All right, thank you.
And continued. Just was rubbing my face in that. The other one was set for the 13th. In case you forgot, Judge, because you're old. Court calls the case people versus Timothy Lacey.
Asphalt for the people.
Good morning again, Your Honor. Robert Ellman with and on behalf of Mr. Lacey.
Your name, sir?
Good morning, Your Honor. Timothy Lacey.
All right. And this is the co-defendant of the other gentleman.
That's correct, Your Honor.
Correct, Your Honor.
I'd adjourn, grant the adjournment. Probable cause will be adjourned to November 13th, 2025, 9 a.m.
Thank you, Your Honor. May I address bond?
Have at it.
Thank you. Your Honor, Mr. Lacey's bond is currently set at, I believe, $150,000 with no 10% privilege. What I'd be asking for is a 10% privilege. He is the father of 3 young children. He's the sole provider for his family. He has strong ties to the community. I actually spoke with his mother this morning, who's very supportive of him. He has a home in the community to go to if released on a tether. He runs his own business. He also works part-time at Habitat for Humanity and is also enrolled through WCC for HVAC trade school, Your Honor. And so I believe that based on his community ties, a 10% privilege would be appropriate. And Your Honor, I'd also note that part of the request for this adjournment, I'm not faulting the prosecutor's office, but I don't have discovery yet because I was newly retained. And so that's part of the reason for the adjournment. That, of course, now, if there is no bond reduction, Mr. Lacey would be in custody. And so I'd be asking for, Your Honor, at least a 10% privilege on this matter. Unlike the co-defendant, Mr. Lacey is only charged, I believe, with unarmed robbery in this matter. So it is a different charge. And I think the bond consideration should ultimately be different.
That is correct, Your Honor. This person is charged with unarmed robbery. I'm going to be revisiting that as I evaluate taking these cases to preliminary examination and trial if necessary. I will let the court know that at the time of this offense, the defendant was out on bond for a domestic violence related malicious destruction of building charge, wherein he is alleged to have destroyed the window of his child's mother's house. So he was already on bond with bond permissions not to be in possession of any weapons or to engage in any criminal activity, and then was involved in this robbery incident. I do believe that the bond that's currently set is more than fair. I'll let the court know he does have a prior juvenile adjudication for assault with intent to rob while armed.
Anything else, Mr. Chairman?
No, Your Honor. Thank you for listening.
Given all of that, I ain't going to deny any reduction in his bond. I'll leave his bond as set. The bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case People versus, is it Hytham Al-Shalabi?
Under Hannah Apple, here on behalf of Mr. Al-Shalabi. State your name for the record, please.
Hytham Shalabi.
Your Honor, we ask that this matter be set for preliminary examination, please.
Discovery is complete.
Yes.
People have their witnesses available on the 10th or the 13th. Which would you prefer?
We did the 13th, Your Honor.
Of course you would say.
Thank you.
Preliminary examination in this matter will be set in person November 13th, 2025, 2 p.m. That's before, well, no, I'm sorry, 9 a.m. 10 a.m. before Judge Barr.
Barr, okay.
Thank you, Your Honor.
Thank you.
Thank you.
Bond will
Thank you,
continue.
Juan.
Thank you, sir. Court calls the case People versus Spencer Norton.
That's calls to people.
Edward Lucas on behalf of Spencer Norton.
Your name, sir?
Spencer Norton.
All right.
Your Honor, I'm asking for 2 weeks. I'm waiting for some video discovery.
Without objection, probable cause conference will be adjourned November 13th, 2025, 9 a.m. Bond will continue. Thank you, Mr. Norton. Court calls case of the People versus Malik. Can't read the writing. Al-Sadie.
That's calls to people.
And Stephanie Cannon on behalf of Mr. Malik Asadai. And could you state your name for the record?
Malik Said.
Oh, yeah, you have to keep your hands out of your pocket. Your Honor, we are adjourning this for plea negotiations on my client's behalf. We're asking for a 2-week adjournment.
Probable cause conference will be adjourned November 20th, 2025, 9 a.m.
Thank you, Your Honor.
Bond continue. Thank you.
What do you think here?
Court calls case People versus Terrence Smith.
That's calls to people.
Edward Lucas for Terrence Smith.
Your name, sir?
Terrence Smith.
All right, I have before me a plea form. Plea form indicates that the defendant will be pleading guilty to the charge of use of a controlled substance, a 1-year offense. Upon his successful plea to that charge, well, the counts are wrong then. He's actually pleading to account 3, not 2. Of use of a controlled substance, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would then be dismissed. That's the court's full understanding of the agreement.
Is
that correct?
Attorney, that's correct, Your Honor.
Your Honor.
May I have him sworn?
The testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be done.
Yes, sir.
State your name.
Terrence Smith.
Sir, it is this court's understanding that you're going to be pleading guilty to the charge of use of a controlled substance. That's a misdemeanor, punishable by up to 1 year incarceration and a $2,000 fine plus court costs. You understand that?
Yes, sir.
All right. Understanding that, you still wish to plead guilty?
Yes, sir.
I do have to advise you that when I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Barr in 14A2 District Court. You understand that?
Yes, sir.
Sir, to the charge of use of a controlled substance, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form or went over that with counsel?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
You'll see on the podium, please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
of your own free will.
Yes, sir.
And because you believe that you are indeed guilty of this offense?
Yes, sir.
I don't know where my complaint is, but let's find it. on the date of September 8, 2022, at the location of 505 South Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have fentanyl in your possession?
Yes, sir.
Had you used it?
Yes, sir.
Did you know what you were using was fentanyl?
Yes, sir.
All right. Sir, if I do accept your plea, I have to advise you that it's between the time of my acceptance of your plea and the time of sentencing. If you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or inducements which have led to this plea?
None that I'm aware of, Your Honor.
Your Honor.
And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
Court will accept the defendant's plea to count 3, and I have amended or corrected the form to accept this plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
November 12th at 10 a.m.
12th,
Yes.
November 12th, 2025, 10 a.m.
Yes.
10 a.m. before Judge Barr.
Thank you, Your Honor. If I could address bond.
Yes, you may.
Your Honor, he was remanded last week. He was testing at community corrections, got a positive test. I met with him yesterday. I think he has the understanding, and he gave some explanation last week of what happened. He's asking that the court reinstate his bond as a PR bond, allow him to go back to community corrections and test. And obviously he's going to have to continue to test negative all the way up until sentencing. That may have a bearing if he's going to test positive with Judge Barr between now and sentencing. So I'd be asking for a PR bond.
I'm going to deny your request. I will indicate I'm going to leave that to Judge Barr after probation sees him within the next few days, and certainly they can make a recommendation to Judge Barr regarding his release in this matter, but I'm going to deny that request. His bond will continue at this time. All right. Thank you. Court does call the case of People versus Kristen Anthony.
And Stephanie Cannon on behalf of Miss Anthony. But not with, Your Honor.
Really?
I
went almost the whole morning without a bench warrant.
And you could continue. We could just adjourn this. I'm asking, maybe, no. And how, good morning to you in court, Your Honor. Yeah, I saw that.
Yeah, you did.
I did.
Okay, go ahead.
Just asking for the adjournment.
Yeah, okay.
Yeah. Are you?
Bench warrant will issue for defendant failure to appear.
Thank you, Your Honor.
Bond is set in the amount of $25,000 cash surety. That warrant will issue immediately.
25,000, take care.
Yes, ma'am.
Thank you.
Court does call the case People versus Robert Barner.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Morning, Rob Jaco on behalf of Mr. Barner. Robert, would you say your name for record?
Robert Barner.
Judge, today's time date for a PCC in this matter. We're asking to set this for a preliminary exam.
Discovery is complete.
99% of it, Your Honor.
There's one report, Your Honor, that's outstanding. I have requested that from the OIC.
One report?
There's a police report that describes the initial stop.
Okay. Well, I'm going to indicate that discovery is complete except for the initial stop report.
That's correct, Your Honor.
If we don't have that, that's not going to be a basis for adjournment.
We'll have it, Judge.
All right. And, oh gosh, it's Kilowald. This is going to be really complicated. I have 2 days, Mr. Kilowald, that I'm going to set. I can set this. I can set this for the 10th, if the people would have their witnesses available, or I'd set it for the 13th. On that date, I have 2 additional two times. Because as I was explaining to Ms. Valtez, I too also do prelims. So.
2 p.m.
Does it make it? Which day? They're both in the same week. Judge, can we go on the 13th? You being the kind and considerate.
People have their witnesses available to 13th.
See no reason why not.
All right. Preliminary examination in person, November 13th, 2025 at 9 a.m. or at 10 a.m. That's
you,
before
Judge?
Judge Barr.
Judge Barr. Thanks, Judge.
Bond continue.
Appreciate your consideration.
Thank you, sir. Court does call the case of the People versus Santana Arlington.
Morning, Your Honor. Assistant Public Defender Chelsea Virgils with and on behalf of Santana Arlington, who appears via Zoom.
Ms. Arlington, please unmute and state your name.
Hi, Satana Arlington.
Thank you.
Your Honor, we're just asking to adjourn briefly for a plea discussion.
Probable cause conference, November 20th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, ma'am. Court does call the cases of the people versus John Devine.
People.
All three cases.
This is Public Defender Natalie Pate with and on behalf of Mr. Devine, who is approaching. State your name for the record, sir.
John Patrick Devine.
Thank you.
Thank you, Your Honor. As to all three cases, I'm requesting an adjournment. We did receive the discovery in the most recent case yesterday, but I still need to review it and then review it with Mr. Devine.
Thank
Then I'm also asking, excuse me, to address bond when appropriate.
I will adjourn probable cause conferences to November 13th, 2025, 9 a.m. As to bound.
Thank you, Your Honor. I'll start out with a bad fact, so to speak. So Mr. Devine does have three cases before Your Honor. One of them is a 2022 case that he was bench warrant status for failing to appear for a probable cause conference back in May of 2023. I asked my client, frankly, why he missed court that day, and he advises that he does have a traumatic brain injury, and frankly, he forgot about court. I asked him moving forward if he was released, how he would get back to court, and he advised me that he had a case manager through Michigan Ability Partners. I was personally able to speak directly to his case manager. Her name's Wonder, who advises that she does work with Mr. Devine. And then she also mentioned that she said no problems with him and he's a nice guy, which of course didn't surprise me. But she also advises me that not only can she work with him to remind him of his court dates, she can also arrange rides for him to get here to court. She also advises that through this MAP, the Ability Partners, he does receive the housing voucher that covers his full housing and utilities. He does stay at an apartment, I won't say out loud, in Ypsilanti, that the court should have the address. He resides there by himself. His case manager, Wonder, also stated to me that she has been discussing and working with him about getting an application in for him to get SSI. So that being said, I do believe he has a good support system in place to get him back to court. Two of the cases are possession related, and he does understand that if released, he would likely be ordered to drug test and has no issue with that. I did speak to his case manager as well that I would advise her what happens in court, any bond conditions, so that she can help get him on the path. I'm
How did he
asking,
come into custody?
I believe one of the newer cases, Your Honor.
So there was another offense, and then that brought him on the other ones that he hadn't appeared on.
Other one he hadn't appeared on, correct, Your Honor. And the only thing I would like to add is his bonds is currently set on the case that he was in bench warrant status on. It's set at $2,000. And I believe the other matters in front of Your Honor said it's 1,010%, so effectively $100. We're asking if he'd be released on his own recognizance.
I don't need a response, given that he was picked up on new charges. I get the circumstance that he's in, but he's picked up on new charges that brought him on the old charge. The court's going to decline at this time to reduce his bond. So his bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Anita Barnes.
Overwater Assistant Prosecuting Attorney for the people.
Assistant Public Defender, Tanabe, Your Honor, on behalf of Ms. Anita Barnes, she should be on Zoom.
Mr. Barnes?
Barnes, could you state your name?
Yes,
Anita
I can see
Barnes?
it. State your name, please.
Anita Barnes.
Thank you.
Judge, we'd like to set this matter for preliminary exam, please.
Really?
Yes.
Okay. Discovery complete?
To our knowledge, Your Honor.
Okay. Would everybody be ready on the 10th?
I'm aware of no reason why we couldn't.
10 should be fine with us, Judge.
I would ask.
You
But no. Preliminary examination will be set November 10th. That's a Monday. That's a Monday, 2025. That's 9 a.m. before Judge Valvo. All right. Bond will continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Ms. Barnes. Court calls case People versus Stephen Kimura.
Stephanie Cannon on behalf of Mr. Kimura, who's approaching.
Your name, sir?
Stephen Kimura.
Thank you, Your Honor. I did email this morning to the prosecutor's office our request for inpatient treatment. In his felony matter before Judge Mood on Monday, she agreed to release him to long-term inpatient treatment. And I'm asking if the court would be inclined to
Would match that. Yeah, I'm not going to have a problem signing that if he wants to.
Okay. Your Honor, outside of that, we did receive discovery. I want to show it to my client. We got the video evidence that we needed. I do need to show that to my client, so I am going to ask for.
When you guys are preparing these orders, and I told you
What do you need?
that I certainly don't do that, he would be released, but it would be on a tether.
Your Honor, however he gets released to inpatient treatment,
Okay,
he
but
will be released
you
to
can
inpatient.
prepare a new order just indicating that language in it.
Yes, I can redo it, Your Honor, and get it to the court.
All right, so what do we want to do on this case?
Your Honor, we're just going to ask for an adjournment. I do want to go over that evidence with him so he can decide whether or not he wants to waive or set it for preliminary exam.
Grant the adjournment, probable cause conference, November 13th, 2025, 9 a.m.
Thank you so much, Your Honor.
Bond continue. Thank you. Court calls case People versus Nathan Burgess.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
The judge, Portia Houston, Assistant Public Defender on behalf of Mr. Burgess. Mr. Burgess, please state your name for the record.
Yes, Nathan Burgess.
Thank you.
Portia, got up. We have awoken the sleeping giant. Go ahead, sir.
Thank you, Judge. I am here. I have spoken to my client and to Mr. Overwater. We are in discussions on an offer on this file and a potential resolution. I'd ask for a 2-week adjournment and hopefully we'll get it wrapped up, Judge.
Probable cause conference in this matter will be adjourned to November 20th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge.
Thank you.
Thank you, Your Honor.
Court calls case People versus Marcus Napier.
Assistant Public Defender Natalie Pate with on behalf of Mr. Napier, who is approaching. Please state your name for the record, sir.
Marcus Napier.
Thank you, Your Honor. I have discussed this matter with my client, and I believe discovery is complete with the exception of the 911 call that is on the way, and I did discuss this with the people. I would be asking to set this matter for preliminary exam, understanding that if for some reason we don't have the 911 call by then, it wouldn't be the basis for an adjournment. Excuse me. Sorry, sir.
And I found that, Your Honor, they usually come pretty quick.
Do either witnesses available on the 10th?
We'll try.
Preliminary examination in person will be set November 10th, 2025, 9 a.m. That is before Judge Valvo.
Thank you, Your Honor. Thank you, Your Honor. Sorry.
Bond continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Rodney Carter.
The public defender, public hearing on behalf of Mr. Carter.
Mr. Carter on Zoom. Take that as a no.
Negatory, go shredder.
Okay, Judge would ask for an adjournment for the record.
What?
I'd ask for an adjournment for the record.
Oh, Miss Apple's so nice. I almost always want to do it, you know?
Trying.
But I've got to be fair to everybody. And just as mean. Sometimes that's fairness. Benchmark will issue for defendant's failure to appear. Bond will be set amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case People versus Ronald Sims.
I should call this with people.
Assistant Public Defender Elsie Virgil with and on behalf of Ronald. Mr. Sims, please state your name.
Ronald Sims. Thank you. You're requesting an adjournment.
Yes, if possible, could we get the 13th, Your Honor? He has a court date in circuit court on the 18th, hoping to move this along before then.
So at what point do Virgil think she could ask for what date? Huh? Right now? Oh.
It was
Did
a mere
somebody tell her
suggestion.
that? I think Cannon told her to do that.
I'd be a trainer.
And I'm glad she has shed most of what you probably taught her. Of course, I can give you the 13th. We'll adjourn it. Probable cause conference November 13th, 2025, 9 a.m. Bond continue.
Much appreciated. Thank you.
Thank you. See, that's it. She's so nice. So I know she wasn't taught that by Cannon. Just saying. Court calls the case People versus Mia Caruso.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Chairman Dadish, on behalf of Ms. Caruso, who is approaching, can you please state your name for the record? Mia Caruso.
Honor. Do you need her to repeat her name?
She said her name.
Okay, I
Did
didn't
she?
hear it. I thought it was just low. We are going to.
No, I heard what you think. You're old and you can't hear.
Well, you
Is that what
usually
you were
say.
saying?
No, that is not what I was saying.
Yes, it is what you're. I'm hurt.
I'm sorry.
Okay, go ahead.
We're going to be setting this matter for preliminary examination, Your Honor. To our knowledge, all discovery is complete.
All discovery is complete.
To our knowledge, yes.
People have their witnesses available on the 13th.
I expect we will.
Preliminary examination will be set November 13th, 2025, 2 p.m. That will be before me. Bond will continue. All right. Who's here with her? How old are you, young lady?
You said how old I am?
Yeah.
20.
20. Who's here with you?
My father.
Okay, I thought so. You're all up under him. My daughter would be with her dad. When she was here. Okay, thank you. Court calls the case, People versus Donovan Smith.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr.
He was definitely about to call that out. He thought that that was a relationship because he said you were all up under him. So in other words, probably like sitting underneath, underneath his arm like that, tucked up in here probably. And if she would have said my boyfriend or something, he probably would have had some thoughts to say to her about that. I don't know if you guys picked up on that, but he was definitely questioning it for that reason, I think.
Smith, Mr. Smith, state your name for the record, please.
Donovan Smith.
Your Honor, I have 2 requests. I know.
I'm only giving you one.
The first is easy.
Okay, I'll take that one.
We're asking for an adjournment of the PCC. I believe we received the media discovery this morning. Additionally, there's forensics from the state lab that we're waiting on. Who knows how long that's going to take.
Right.
The second is bond. Mr. Smith would like me to address bond, if I may.
Yes, is he held on anything else or is this?
This is it.
Okay, go ahead.
So Mr. Smith has I believe his bond is currently set at $50,000. He is asking for a reduction, either a personal bond or at least a 10%. He would go home to his mother's home in Detroit. He has no reason for being in Washington County, so he's happy to stay out of the county. He's happy to wear a tether if the court would like to order one. He is not working right now, but he is a caregiver for his grandmother who was ill. She recently had heart surgery, so he does things around the house for her, helps care for her many medical issues. He is planning on going to school in December as well. So given all of that, we are asking the court to consider a personal bond or a reduction.
Response.
Your Honor, the people would object. Mr. Smith currently, according to Lean, has a felony carrying concealed weapon charge that was bound over in 3rd Circuit Court. He also has a felony unlawful driving away that was bound over in 6th Circuit Court. And then here in Washtenaw County, he is alleged to have fired a gun at a building. There are numerous shell casings that were recovered from the scene. He ran from the scene. He had to be chased down. There was I believe that a canine unit was called and had to find him. And we are waiting for DNA on these shell casings to strengthen this case. So the people would object to a bond reduction and believe it was set appropriately.
So
That guy's been waiting all day to say that. Not even kidding. He's been waiting all day to say that.
he was on bond or some other type of court proceeding regarding a weapons charge, and then this comes up where it involves the firing of a weapon.
I can't confirm that he was on bond, Your Honor. My record only indicates that matter was bound over in October of 2024. I don't have a resolution of it in 3rd Circuit.
Got it.
I don't know if this helps, but he's on HIDA for in Wayne County for the weapons charge.
So he's okay. So he's under sentence on a weapons charge and then picks up a case that involves discharge of a weapon at a building. Anything else?
He says he's been compliant with his probation there.
Except maybe the picking up of another charge.
And
particularly a weapons charge.
We do dispute these allegations.
I understand you do.
And he is set for sentencing in Oakland County on that other case on the 6th.
So he's under sentence, or he's about to be sentenced on something else.
Even if I go there too.
And this offense happens.
Misdemeanor because it was attempted.
He says it's going to be a HIDA misdemeanor resolution there.
Okay. So actually, Ms. Perrini, we're wrong about something. Both of your requests are very easy. Motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Sure, well, I was just being honest, because it's how I am. What'd you say, Cannon?
I said, yes, Your Honor, you're an honest man.
If that's what you said, you wouldn't have had to mumble it. The court calls the case, People versus Edward Castro.
Actually, calls to the people.
And Assistant Public Defender Nicholas Bunkovich on behalf of Mr. Castro.
Edward Castro.
Thank you, sir.
I know you could hear him, Your Honor.
This is our guy. Let's see what Mr. College is up to.
Thank you, Mr. Mayor. All right, what are we doing?
At this time, Your Honor, I'll be requesting an adjournment. We have begun the referral process for sobriety court up at the circuit court. I have submitted the
Okay.
referral, so Ms. Sample did give me an estimate about 3 weeks to get this interview done. But that is what based upon her time. I know she's down a staff member right now and is training someone new. So it may be a little delayed, but that was the estimate I got from Ms. Sample.
I think that makes sense, Your Honor. He is out of custody, so 4 weeks might be.
So, but she's saying 3 weeks to get it done.
That's from my understanding of the email, Your Honor.
And somehow or another, there's then gonna have to be the other part of that process.
Yes.
Correct. Mr. Buckovich and I have been in lots of communications. There's no guarantee of felony drug treatment court, but it's something I don't think might be a good choice.
All right, here's what I'll do, because I would normally go to the 20th, but that's your 3-week mark. And then
Yes.
the next week is actually Thanksgiving.
Yes.
I mean, I'll be here, but probably people don't want to come in. No, I'm kidding. And then it would be that Tuesday, or the Tuesday before, which I just don't think is practical. So what I'm going to do is I'll adjourn this out to December 4th. All right, 2025 at 9. And then we'll see where we are. All right, Mr. Castro, thank you, sir. Bond continue.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Kevin Smith.
Ashley Feltus for the people.
That's a bummer. We didn't get to hear what he was in here for.
Your name, sir?
Kevin Smith.
Thank you.
And Your Honor, I have been in negotiation with the prosecutor on this case. A potential resolution would involve him participating in mental health court. So I am going to get him screened to see if that is something that we can do here.
And what's our time frame on that? Do we know?
Do not.
Your Honor, could I have at least 3 weeks? I know we have Veterans Day coming up.
What?
What, Your Honor?
We have Veterans Day coming up?
Yeah, and I
At what
just,
point do we figure that out?
I celebrate all week. So. Your Honor, we would like at least 3 weeks.
You think, I mean, I don't have a problem putting that out, but.
Well, I'm providing all the paperwork now. I am not sure how long it takes, but
Why don't we, this is a mental health court, right? So.
yes.
Let's see if we can get him in. I would put it to the 20th, but let's see if we can maybe get an answer. I'm gonna put this on a Tuesday, November 25th, 2025 at 9.
Thank you, Your Honor.
Your Honor, do you want me to address bond? Can we address bond, Your Honor? Your Honor, my client.
Yes.
At the time of this incident, he was just during this time frame, he was unmedicated. Subsequently, and after this, he is now taking a pill every day. He gets an injection. The crux of his issues definitely stem from mental health needs and homelessness. Since then, his mother has stepped up, and he can live with her. He wants to go and live with her. He can be released on GPS tether. So he's asking the court to allow him to be released to his mother's care.
What city does she live in?
Jackson.
In Jackson?
Yeah.
Response from the people?
Your Honor, I would ask that the court continue the bond as currently set. I think there was at least one failure to appear on this file.
Yeah.
And I would also note that I'm very glad to hear that now on an injection and getting the treatment that he needs. So I'm concerned that should we release him without structured mental health court around him, there could be continued failure to appear.
Like, they literally just said that he's homeless, and that's what the crux of his issues are: homelessness and him not being medicated. But yet you're going to say that he has one failure to appear, and that's a concern? I mean, come on. He probably didn't show up because he was homeless.
And what I'm going to do is I'm going to deny your request for a change in bond. I would, after the initial evaluation and screening is done, whatever information can be provided, I'm more than willing to look at it again.
Thank you so much, Your Honor.
All right. So bond. Thank you.
Later.
All right, there we go.
Oh my.
Oh my. Court calls the case, People versus Corey Copeland Nash.
Marshall Feaster, Assistant Public Defender on behalf of Ms. Copeland Nash. Please state your name for the record.
Corey Copeland Nash.
Thank you, Judge. I have spoken to Ms. Nash and I have reached out to, it was Mr. Bannis who I reached out to on this file. We are trying to get a resolution on this file, but we are not quite there yet. If we could please have a couple of adjournment, hopefully we'll get it resolved.
Probable cause, November 20th, 2025, 9 a.m. bond continued. All right, thank you. Court calls case of the people versus Derek Stewart.
Assistant Public Defender Hannah Apple, here on behalf of Mr. Stewart, who's approaching now.
Your name, sir?
Derek Stewart.
Thank you. You're requesting an adjournment.
Yes, Judge, and I did wish to address bond on Mr. Stewart's behalf, but we are requesting an adjournment. I did reach out to the Forensic Center regarding a potential timeline. The email that I received said that it's still several months.
Competency review, because we don't have a report. They said several months.
The email that I received stated, as a result, we anticipate that it will be several additional months before Mr. Stewart will be admitted to restoration.
Well, let me do this. Let me just set it for December 11th. That's about us. We'll see where we are at that point.
The 9th,
The
December
11th of December.
December 11th.
All right, as to bond.
Your Honor, based on that correspondence with the Forensic Center, Mr. Stewart is asking for a release on a personal bond. He has been in custody 154 days. This is the only matter holding him in custody at this time. He reports that he would reside at the Delana Center and that he is on disability, so he's unable to work at this time. But I understand the severity of the charges. However, they are 4-year felony. He's been in for several months already, and with the anticipation that this could be an additional several more months until he can get treatment, I'd ask for a tether and for him to be released on a PR bond.
Any response from the people?
Your Honor, I think there was previously a time when he had been released on a tether, and then there was a bond violation where he was in possession of a fixed blade knife. Excuse me, I almost said it wrong. I'm just concerned about that. We did give him that chance, and then we had that violation. So I'd ask the court continue to bond as currently set. I'm terribly sorry about the delay of treatment, but
Yeah. What I'm going to do is I'm going to deny his motion to change bond at this time. However, what I would indicate is that if, given all of the circumstances, if the people and the prosecutor can come up with some type of structured plan to release him under, then I will certainly take a look at that. It may be difficult with him residing at the Delana, but that I'm looking for something like that. All right, so I'm not saying no, I'm just saying no, give me something else. And
Okay, I will work on that, Judge.
thank you.
Thank you.
Court calls case people versus. Hold on a second. Is it Zakara? Precious, Zakai, Daphne, Persiga.
people.
Okay, some of that, there's something I need to be able to leave out. That's like 30 names.
Assistant Public Defender Chelsea Vergil with and on behalf of Zakara Daphne Bersiaga. Please state your name.
Zakara Daphne Bersiaga.
Hold on. I had to do 5, she did 3. Okay, go ahead. Thank you.
Your Honor, we are asking for an adjournment in this case. I think we should be able to resolve it with a plea, just need a little more time.
Probable cause conference November 20th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Thank you.
Court does call the case of the people versus Christopher Thax.
Overwater Assistant Prosecuting Attorney for the people.
Again, Judge, Torres Feaster, Assistant Public Defender on behalf of Thaxton, who is approaching the podium. Please take your name for the record.
Christopher Thaxton. Thank you, sir.
Thank you, Judge. I did meet with Mr. Thaxton and have had conversations with Mr. Overwater to try and resolve this matter. There are videos in the file that I am reviewing with my client, and he's asked me to go out and look for a few other additional videos. So we're going to kind of do a little bit of investigating, Your Honor. I'd ask for a 3-week adjournment, please, or more.
Will the 13th be enough time for you to get all that done, you think, or?
Yes, it's only one location we need to go.
Okay. Probable cause conference November 13th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Thank you. Court calls case of the people versus David Davis.
And on behalf of Mr. David Davis, who's approaching. And we are,
What?
yeah, we're going to elect.
What were you going to say?
No, I just wanted to let you know we were waiving the exam.
You weren't sure what?
I'm just gonna waive the exam. Were you timing? What was it?
I was trying to figure out how long this was gonna take. Yeah. No, go ahead.
That's what I felt it. We're gonna, my client is elected to waive his exam, Your Honor.
Yes, okay. Is that correct, sir?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further proceedings.
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on count 1 with 2 through 7. With counts 2 through 7 following.
Thank you, Your Honor. At this time, my client will stand mute as to those charges, and we would waive the formal reading of the information.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all 7 charges. Pretrial in this matter will be set for
December 22nd at 1:30 with Judge Moon.
December 22nd, 2025, 1:30 before Judge Hamud.
Thank you, Your Honor.
Bond will continue. Thank you, sir. Court does call the case of the people versus Andrew Travis.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Natalie Pate, on behalf of Mr. Travis, who stands to my right, please state your name for the record, sir.
Andrew Jacob Travis.
Thank you.
Thank you, Your Honor. Your Honor should be in receipt of a green sheet. I'm requesting a very brief adjournment. The prosecutor is on board with my proposed resolution as of last night, and during the beginning part of the docket, he did submit to me the plea form, but I do need to go over that with my client further. My client is being held on a Wayne County matter. I will say for the record as well.
During the matter to November 6th, 2025, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Denali. Is it Deloach?
Correct, Your Honor.
Analyst on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Deloach. Mr. Deloach, can you please state your name for the record?
Dinali Deloach.
Like,
Dinali Deloach.
Got it.